I've done that. And all right, Ms. Gonzalez.
Okay, the Court of Appeals for the 8th District of Texas is now in session.
Thank you. The court is here today on Velasco versus Michael No, individually and doing business at Sun City Women's Healthcare. And I understand, Mr. Lopez, you're going to be arguing for the appellant and Ms. Faust for the appellee. Is that correct?
That's correct, Your Honor.
All right. Thank you. We have had an opportunity to read the briefs and look at the record. I just let y'all know that as you argue this morning that we've had an opportunity to review everything. We also have a timer. So we are doing 25 minutes for each side and 15 minutes for rebuttal. And hopefully y'all can see the timer above you that will give you an idea. And with that, Mr. Lopez, you may proceed. Thank you.
Thank you. May it please the court, counsel. Velasco is a very fact-intensive case. First of all, Ms. Velasco is a Catholic woman for whom abortion is not an option. This case involves a bilateral tubal ligation, and I'll refer to it with the court's approval as BTL. That way it makes it quicker. The record indicates, it shows that Ms. Velasco discussed the BTL with the defendant's, that is defendant No's staff. It was agreed and understood that she, at that time, during her pregnancy with her third child, that she could not afford to have a BTL. But there was also agreed and understood that if she came up with the $400 to pay for it, that Dr. No would then do that during the cesarean section that she was going to have on July the 15th, 2014. On the 14th of July, Dr. No's office accepted the $400. She paid it, they accepted it, and she had her cesarean section on the following day. What happened was that Dr. No did not ever tell Ms. Velasco that he did not do the cesarean section on July the 16th, 2014. In fact, at her postpartum visit on August the 4th, 2014, about a month after her delivery, it's noted in the records, quote, PT, which is patient had a BTL, unquote. Then, and Dr. No's own records, there's a notation that his office requested the OR report. Again, we do not know if he ever got it. We don't know if he reviewed it, if he did get it, if he reviewed it. But in either event, he never told Ms. Velasco that he had not done the BTL. It was not until she came up pregnant again in October 2015 that she went back to Dr. No's office and to inquire as to what had happened. And to be quite blunt, they basically blew her off and said, "We're not a public assistant, go somewhere else." Well, she went to Sierra Providence Medical Center where she had her cesarean section done a year earlier, and they advised her that she had never had the BTL done during her July 16, 2014 cesarean. Now, the defendant and the appellee here filed 7 motions for summary judgment in the trial court. I do want to advise the court that contrary to the appellee's representation to this court, Judge Alvarez, the trial court judge, did not rule that the plaintiff's causes of actions were healthcare liability claims. That's not what he says in all of his orders. So in this case, I think there's 2 questions. One is, were the appellee's acts and omissions inseparable from the negligence claims? The answer to that question is no. There are 2, and the reason for that is that there are 2 different time periods. The first time period is during her pregnancy, during the time that she was being cared for by Dr. No, until July the 15th, 2014, the day before her delivery, and until August the 4th, 2014, when there was a postpartum visit. So regarding what had been agreed to between Dr. No and Ms. Velasco, the second time period is beginning August the 4th, 2014 until October 2015, when she discovered that she was pregnant. At that point, Dr. No either knew or should have known that either A, no BTL had been performed, or B, there was a question whether or not a BTL had been performed. Both of those triggered the duty by Dr. No to advise the plaintiff of either or both. The second question is, were the plaintiff's cause of action merely recast as healthcare liability claims? The answer to that question is no. Now, regarding the brief that I filed on behalf of Ms. Velasco, in the trial court, the defendant argued that the only cognizable claims that could be brought against the defendant had to be based on allegations of medical negligence. Therefore, the defendant claims that all cause of action had to be dismissed. Well, I will go over those as best I can as in the time that I have. Regarding number one, the defendant's basis for the MSJ on regarding negligence was that the defendant's I'm sorry, let me strike that. There's an issue regarding consent for the BTL. That's the first basis of the motion for summary judgment. But remember, the defendant's own medical record on August the 4th, 2014 states that the patient had a BTL and that she had signed the consent for the BTL. Now,
Mr. Lopez,
yes, ma'am. Yes, Your Honor.
can you repeat that, what you just said? Like where in the medical record?
Yes, ma'am. It's the citation is CR 1411 and then 1392 through 1398. 14, and I believe that 1411 is attached as an exhibit to my brief, which has the doctor's record, which is I think 2 pages long for August the 4th, 2014. But that was the only time that Ms. Velasco ever saw Dr. No after her delivery, after the
Right, so I don't know if I heard you correctly, so I'm sorry, but did you say that she had given consent to the procedure?
Well, the record states that the patient had a bilateral tubal ligation, a BTL. That's what the doctor's own record says. Okay. And on the second page of that record, it says that she believes that she had signed a consent form. Now, there's a question regarding, even if she had signed a consent form, there's a question as whether or not Dr. No could have done the BTL in any event. Because according to Dr. No, that it's got to be a 30-day waiting period from the time she signs it to the time that he can do it. Well, that's not I'm not complaining that he didn't do it. Okay, if in fact he couldn't have done it, my complaint is that he never told her that he didn't do it, even after she went to the August 4th, 2014 postpartum visit, where it says PT, that's patient, had BTL, right? And then they order the OR report. Why order it? They ordered it because there was a question in their mind, like, you know what, there might be a question whether or not it was done. So they ordered it, but there's nothing to indicate that they ever received it. I'm sorry, there's nothing to indicate that they even ordered it, much less received it, much less reviewed it.
So can I just clarify, is it your position that he was obligated to perform the BTL?
Prior to the actual cesarean section, I believe he was obligated to perform the BTL. At least that's what Ms. Velasco understood, that he was going to do it. Now, again, his argument's going to be, well, I couldn't have done it legally. So but again, and if in fact that is correct, that's not my complaint. My complaint is that he never told her that he hadn't done it, even though he knew that she believed that he had done it, and his own record states that he had done it.
So Lopez, is there anything in the record to indicate that he believed he was expected to do it?
In his deposition, he states that he doesn't know what his staff told Ms. Velasco, but he does take responsibility in his deposition for what his staff did or did not do.
Right, and I understand that. That's taking my question a slightly different direction from why I was asking. I was following up on Justice Palafox's question, because if he's saying I couldn't have done it because she didn't sign the forms, but I didn't give her the forms because I had no idea I was even asked or expected to do it, then it makes it an interesting defense that the reason I didn't do it is because it would have been illegal. And the reason it was illegal is because I didn't do my part when she asked me to. And so I'm trying to find out if there's anything in the record before the date of or moment of surgery, indicating that he himself knew or understood that there was an expectation that he would do that procedure?
I do not believe that there's anything in the record that says that Dr. No himself knew anything about the BTL that was supposed to be done. What we do know is that she had paid his office the $400, okay, and they took her money. And remember, they gave her a refund 15 months later. In November 2015, they had the nerve to credit her account. You don't know why they credited it, but they credited her account for the $400 that she paid for the BTL. Hope that answers your Honor's question.
You did. Thank
Well,
you, sir.
okay, so I would follow up to ask you then, the fact that she paid the money the day before the cesarean was scheduled, what is the legal significance of that in relation to the claims?
I'm sorry, Your Honor. I'm not sure that I understand the court's question. I mean, there was an express representation, okay, by taking her money, okay, and negotiating. I think she paid by debit card, okay, and taking her money. That was a representation, express representation by Dr. No and or his office that they were going to do the BTL. Ms. Velasco signed whatever she was given to sign. She wouldn't know if what the requirements were by law to wait 30 days if he didn't tell her. I mean, she went there with the expectation that she was going to get the BTL, which she had paid for. Otherwise, think about it. Why would she have gone back 15 months later and said, "Hey, what happened? You did a BTL. Why would we be here?" If it wasn't for her belief. It may have been incorrect. I understand that, but it's not her job to understand what Dr. No's responsibilities are in relation to the BTL. It's Dr. No's responsibility to tell her, "I can't do it," or to tell her after the cesarean, "Hey, I didn't do it, and this is why." And that is our complaint, is that he never told her. Once he knew there was a question, he never told her. He kept silent.
All right, so you're saying the fact that the office received and accepted the payment, it imputed that knowledge to the doctor, and then he had obligations flowing from that knowledge.
Absolutely. And in fact, in his deposition, he says he takes responsibility for whatever his staff did or did not do. That's in his
All right,
deposition.
so my question then after that is, which does that fall inside a healthcare liability claim or outside the healthcare liability claim, or both?
I think it's both. I think it's both, and that's why I said there's two different time periods: the time period before the cesarean and the time period after the postpartum visit. Okay.
All right, so then can you focus on the healthcare liability aspect of it, and what would be the damages that would be recoverable should it be a recoverable healthcare liability claim?
Okay. The damages there's four different categories, and I think I mentioned them in the Flax opinion. Right. The first is a no recovery rule, which bars all damages. The second is a full recovery rule, which permits all damages, including the support and maintenance expenses. Number three, a benefits rule, in which the support and maintenance expenses are allowed but are offset by the amount of the child's benefit to the parents. And fourth, the limited recovery rule. And as I understand it, the full recovery rule and the benefits rule have been rejected in Texas. So that leaves us only two: the no recovery rule, which bars all damages, and number four, the limited recovery rule, permitting only certain types of damages. In fact, this court in Noggle versus Third, 917 Southwest 2nd, 287, 1995, that was a summary judgment case based upon a statute of limitations. And this court cited Flax as authority for the recoverability of damages other than medical expenses in a wrongful pregnancy lawsuit.
So in her particular case, in our record, what damages is she claiming here?
She's claiming the mental anguish damages that she has sustained as a result of having an unplanned pregnancy, and also the support. She's asking for the cost of support of that child that she had not planned for. The defendant in this case says that she didn't want her child. Well, that just is not true. What she didn't want was to become pregnant again. And that's what she took the proper steps to avoid that. That is paying for and getting what she thought was going to be a bilateral tubal ligation during her cesarean section.
And has any Texas court upheld that type of recovery for the cost of the support of a child, a healthy child?
As I understand it, the Supreme Court has yet to rule regarding the cause of action for the wrongful pregnancy. All right. As far as the damages are concerned, the question is whether the courts have, any court has upheld, excuse me, could you repeat that, Your Honor? I apologize.
Well, what I understood is you were looking for two categories of damages: mental anguish and the cost of support for this child who undisputedly is a healthy child. And I'm asking, is there any Texas case law to support the recovery of those two categories?
The cases that I said to the court were Garwood versus Locke case at 552nd Southwest 2nd 892. In that case, the plaintiff sought damages for medical expenses associated with a pregnancy, loss of earnings, and physical pain and mental anguish. The court held in Garwood that the court held that the pleadings in Garwood clearly put the recovery of medical expenses an issue and remanded the case to the trial court on that point. However, it declined to rule on the recoverability of the other alleged damages. And then I cited the court again to Flax, where the plaintiff sought damages for medical expenses, physical pain, and mental suffering, and permanent physical impairments due to her pregnancy. The Flax court stated that the full recovery rule and the benefits rule had been rejected in Texas, leaving only a choice between limited recovery and no recovery. Relying primarily on Garwood, the Flax court opted for the limited recovery rule, but proceeded to hold that all of the damages alleged by the plaintiff in Flax were permissible under that rule. That is the Flax court. The Flax court stated that there was aware of no Texas cases denying recovery for the other damages sought by the plaintiff. So in answer to the court's question, I guess the Flax and the Garwood cases will be the ones that would apply in that regard. I cited I'm sorry.
Just one last thing then, just to clarify, then you're not mentioning anything about outstanding medical expenses. Does that mean that there's no claim in that category or anything regarding?
As I sit here today, Your Honor, I apologize. I don't remember if that was included in the second amended petition or not. I don't believe that it was, as far as the feature, in other words, the cost for the birth of the fourth child that we're talking about here. I don't remember, but I don't think it was. But I may be mistaken. And during my time that I can, while appellee's given her argument, maybe I can look at the second amendment petition.
All right, and I don't know then, can you address, I'm sorry.
It's quite all right.
You earlier said that there would be claims outside the healthcare liability statute.
Yes.
And so I just wanted you to be able to address your position on what those claims are and what damages flow from them.
The first one is deceptive trade practices. And I cited the Supreme Court case of Sorocolid versus Rhodes. Okay. In that case, the court stated or held that chapter CPRC section 74.004 does not preclude suits under the DTPA for knowing misrepresentation or breach of express warranty in cases in which a physician or healthcare provider warrants a particular result. And that's exactly what happened here, is that Dr. No warranted a particular result. That is that he do it BTL. But then when he didn't do the BTL for legal reasons, let's presume that for the moment, he didn't tell her he didn't do it. So the DTPA continues, okay? He perpetuated the DTPA and he perpetuated the fraud, okay, by not telling her. He or someone in his staff should have said, we've gotten the OR report, okay, you were mistaken, Ms. Velasco. We didn't, Dr. No did not do bilateral tubal ligation on you because he could not. That would have allowed her, or yes, to take the proper precautions not to get pregnant again, or to decide to, hey, I'm going to go ahead and have it BTL now. Instead, he kept his mouth shut, kept silent, and I think that is a deceptive trade practice on the part of Dr. No and or his staff. Then regarding the
Interrupt you as well, Mr. Lopez, sorry.
yes, ma'am.
So really, you're not complaining of the wrongful birth or some kind of failure. You're really complaining about the fact that she wasn't told, and thereby the wrongful birth is the result of not so much the doctor's negligence in not doing it or intentionality, whatever the case may be, but really the fact that he didn't disclose that to her.
That's correct. And just to clarify, Your Honor, a wrongful pregnancy that we're alleging, not a wrongful
right.
birth. Okay.
Right.
Just,
Yeah, I know. I'm learning the distinction. And so
but
go ahead.
the court is correct. Okay, that the complaint is that he didn't tell her. That's the main thrust, and that has nothing to do. Okay, or that can be separated from any medical negligence claim. Okay, and then if you look at from there, like I said, there's two time periods from during the OBGYN care, okay, until the time of the postpartum visit. Then there's a second time period from the date of her postpartum visit until she discovered she was pregnant.
Right.
And during that time, remember, he wasn't her doctor at that point. You know, or at least I mean, I guess arguable. Was he her doctor during that time period, or wasn't he her doctor during that time period? I'm talking about after August of 2014 until she became pregnant. But he had an obligation because he in his record it says OR report to be requested. Okay, well then he should have gotten it, and if he got it, he did one or two things. Either he got it and kept his and didn't say anything to her, or didn't get it and never followed up with her. Either way, you know, he's on the hook, and he admits it and acknowledges in his deposition that he is responsible for what his staff did or did not do.
Wasn't she supposed to return for a second postpartum visit that she did not attend?
It says, I think it says 2 weeks or PRN, you know, as needed. And she acknowledged she didn't go back, you know, because she didn't have any need to go back. Okay, but and again,
but doesn't this confusion, you know, the request for the OR report and needing to learn about what happened there, wouldn't that be what she would learn about if she had returned for that second visit?
But let me answer this way. Remember, there's nothing in the record that says the doctor advised the patient that there was a question whether or not a BTL had been done. There's nothing like that. It is a doctor's own record, okay, where like this is the plan that we have. We're going to order the OR report. There's nothing to indicate that they ever told her that. What we do know is that the record states the patient had a BTL. So I mean that was good enough for her. Okay, so again, it's incumbent upon the doctor and his staff to take the next step, and that's pick up the phone, call her, leave her voicemail, something that says we got the OR report, we didn't do the BTL, come back if you want to or not, whichever. But they didn't tell her that. I mean, this is not a sophisticated plaintiff, but it's I just believe that it was incumbent upon doctor to do all those things which I believe he should have done, and he didn't do those things. And you know what? And let's say that they got the OR report, they didn't call her. So why didn't they call her? Why didn't they communicate with her? Why didn't they send her a letter? They did nothing that's indicated in the record at all that he did.
Let me ask you, Mr. Lopez, do you think that the cases that in which doctors are supposed to follow up with, I can remember a case that we decided 2 or 3 years ago in which an emergency room doctor in the hospital didn't follow up and letting a patient know that she had potentially a very serious diagnosis that she eventually died from. But is that, I think, do you think those line of cases is something that the court should look at? Or you think that that's more analogous to your situation in which some piece of medical information that was vital to the patient was not communicated to the patient? Critical.
Well, I think that we're looking at two different things. Okay, we're looking at negligence, and then we're looking at matters that are not negligence. Okay, it wasn't negligence. Okay, in our position, that was not negligence for the doctor to fail to communicate with the plaintiff after the 8/4/14 visit. Okay, those are separable. They are not one and the same. And that's why this case was pled the way it was. It was pled in the alternative, one medical negligence and the other the remaining cause of action that I have in there. I'm not sure that I'm answering the court's question, and I apologize.
No. I understand what you're saying. No,
Okay.
Thank you. I appreciate it.
Okay. Yes, ma'am.
Your time is up, and Ms. Faust.
May it please the court, counsel. I first would like to start with the question that and the issue that we've all been talking we've been focusing on here, and that is whether the 7th summary judgment motion regarding negligence was properly granted. And in that connection, we of course believe that the trial court did properly grant it because there was no fact issue ever presented on at least two elements of the negligence claim, and that would be duty and damages. Now, Dr. No conclusively established, as the court is aware, that he did not perform the BTL. He could not lawfully because he had no consent form signed. It is a List A procedure that requires a written signed consent. And under federal law, because of CHIPS, the 30-day waiting period after the consent was signed. Therefore, there was no duty.
Okay. Let me just stop you because he's arguing apples, and what I'm hearing from you is oranges. So I need you guys to get together. I think you're arguing medical negligence as a result of not performing the tubal ligation, but he's not arguing that. He's saying the failure to warn or the failure to disclose that it wasn't done. So that's something completely different.
Yes,
so
yeah. And let me address that.
Please.
The claims asserted both, and the summary judgment went to both. And in fact, in response to the summary judgment, and if he wants to concede now that he's no longer contending that, then the court can take that concession. But in response to the summary judgment motion, he submitted Ms. Velasco's affidavit, but he also submitted the expert opinion of his OB-GYN expert, Dr. Johnson, who addressed both prenatal, delivery, and postnatal care, which is this postnatal care is this failure to disclose issue, I believe. And what Dr. Johnson says is that Dr. No's conduct fell below the standard of care when he allowed a high-risk patient to believe her contraceptive requirements were met when he knew they were not, and he made no effort when he had ample opportunity to inform her that she had no contraceptive protection. Now, what this means is this is a healthcare liability claim. This is presented to support her healthcare liability claim. And we know from the Yamada case from the Texas Supreme Court that when the claims all arise out of the performance or failure to perform, that is here, failure to disclose during either prenatal, delivery, or postnatal care, they fall within the presumption that it's a healthcare liability claim. It's an inseparable part of the rendition of that claim. She has not challenged the fact, in fact, she has conceded here in her brief that she also asserts a healthcare liability claim. And all of her causes of action alternatively pled, such as this DTPA action that counsel is claiming is a separate claim that is not a healthcare liability claim, all of those are asserted under the same set of facts. There are no facts different. She will require evidence from an expert to prove or refute the merits of the case. Under the Texas Supreme Court's opinions in Weems and Williams, this means that the Loaisiga presumption applies. It is a healthcare liability claim. It is an inseparable part of medical services. She cannot split her claim into other causes of action when it's based on the same set of underlying facts. The Yamada case says, if all claims are asserted under the same facts, you cannot split them. You cannot artfully plead them as alternative claims such as DTPA. Again, she conceded she has a healthcare liability claim for the, if it's not including now the failure to perform the BTL, it did at the time of the second amended petition, and also the failure to disclose that she did not receive the BTL. She's not challenged that ruling here. And because she has not, and her claim is a healthcare liability claim, and all of the other alternative theories she alleges are based on those same facts, then they're all healthcare liability claims. And all of those, including DTPA, that are based on the same facts, are healthcare liability claims, and they were properly dismissed. Now, in the DTPA case of Saracolet, that was a pre-Chapter 74 case. That certainly is a different kind of case, and the Texas Supreme Court has limited it to its unusual specific facts. It was a promise of an outcome for plastic surgery, and there they did not alternatively plead negligence. The court said, under these unusual facts and limited presentation, the representation that the outcome would be exactly like a photograph was a DTPA claim. Later on in the Gormley case, in the Murphy case, and other cases in the Texas Supreme Court, where we have promises or statements of care, for example, in the Gormley case and Murphy case, where they pleaded allegedly an express warranty not to use general anesthetic. The doctor did use general anesthesia. That claim was not a DTPA claim because it relates to whether the doctor met the applicable standard of care in performing that particular surgery. So Saracolet is extremely limited and has not been followed because the cases that follow that, like this case, plead negligence, plead healthcare liability claims, and use those same sets of facts to alternatively allege DTPA, breach of express warranty, fraud, and here intentional infliction claims.
Counsel, let me jump in.
Yes.
The waters have been muddied here in the course of argument. Are you suggesting that the issues, setting aside whether or not we just had a concession during the first argument for the moment, are you suggesting that the issues related to the failure to perform the procedure are not before us for consideration? So you were talking about an amended pleading and then what happened in the order and then the briefing. Is that what you're saying, that we are not free to consider those issues and we're limited only to the other issues?
I'm not saying that, Your Honor. The second amended petition addressed prenatal, the fact that during delivery there was no BTL, and then postnatal. Motions for summary of judgment were filed after that second amended petition addressing all those claims. I think today perhaps the clarification that was made was more of a clarification, and that is that the focus of the claim is more on the failure to disclose.
Okay, that's what I heard too, but I was confused by some of the other things I've heard as to whether it's been mooted or it has been abandoned or conceded, but the issue that was part of the order and part of the claims and is briefed by both sides about failure to perform, that is still an issue for us to decide. Unless when we go back to Mr. Lopez, he says, I abandon, I concede.
I would agree with that, Your Honor.
Okay, thank you for clarifying. I'm sorry to jump in.
Certainly. With respect to the negligence claim and the failing to inform, I'd like to point out to the court about this postnatal visit and the reference that Dr. No's records specifically say there was there was a BTL performed. That specific notation in the postnatal visit was a recitation of medical history provided by Ms. Velasco. And in fact, the record establishes, for the summary judgment record establishes through Dr. Velasco that Nurse Ramirez, who saw her on that visit, told her that no tubal ligation had been done. She was to have no intercourse. They would get the operative notes for her, and she was to return for the second checkup. She did not return for that second checkup. Now, Ms. Velasco admitted these facts in her deposition. She changed those facts in her affidavit in response to the summary judgment without explaining why her testimony in her deposition was incorrect. And we know under the Texas Supreme Court's case of Blue John versus Navistar, that would make it a sham affidavit for purposes of creating a fact issue, and therefore it could not create a fact issue. So she did also agree that there was no evidence that Dr. No represented that he performed the BTL. Obviously, everyone agrees it was not that it was not performed. There was no evidence he told her she was sterile. That was another ground in the summary judgment. There was no evidence of representation that was made that she had the BTL. Again, the evidence is also that Dr. Velasco discussed with Nurse Ramirez the postnatal visit and agreed that he could not do the BTL at that time because of lack of a written consent and the 30-day waiting period.
Counsel, is there any evidence that he was aware of a request to do the BTL before he performed? I understand in retrospect, he's saying, well, I couldn't have done it because of this, not I didn't do it because of this. So I asked Mr. Lopez, I'll ask you the same question. Is there anything at all in the record that indicates that?
No, Your Honor, there's not.
Thank you.
Not as of the date of the surgery. Regarding injury from not receiving the BTL, at this point in time, she has not received, or at the time of the filing of the summary judgment and the ruling, the response, she had not obtained a BTL. She had become pregnant another time. And then under Texas law, we believe for any injury that would be recoverable under this theory of negligence, she has been reimbursed, recompensated for those. She would be limited to damages for medical expenses for the procedure, which resulted in the unplanned pregnancy. When you have a birth of a normal child, we believe that the more current cases are the cases that most accurately reflect the types of damages that are recoverable under Texas law. And those would be limited to the medical expenses associated with that. Usually it's a sterilization procedure that didn't take, if you will, that resulted in the unwanted pregnancy. The cases most recently, the Crawford case and the Purcell case, have criticized the Flax case. Flax was a much older case out of Waco. It's a no writ case, so the Texas Supreme Court has not considered that issue. In the Flax case, the court did allow for the prenatal, postnatal sterilization expenses, the pain and emotional distress of the mom, loss of consortium, lost wages, and whatever the parent's permanent impairment was. And I don't understand what that particular aspect of the damages component was. There was no award. It was not allowed any recovery for raising the child, the expenses associated with support to the child or education. So again, we believe the most current cases that would be the Purcell case, the Crawford case, most accurately reflect what damages would be recoverable under this type of claim. And because we conclusively established that those damages, she has none of those damages, the summary judgment on negligence was properly granted on the issue of damages as well as the issue of duty. Just briefly, with respect to whether or not all of the claims are healthcare liability claims, and I started down that path briefly, but I think it's important and the court certainly, I anticipate, would do this in its review of the record, but going back and looking at those specific allegations and the theories that are asserted under each of those allegations for DTPA, for example, failing to perform the BTL or failing to notify, there is no evidence of any type of a warranty that it would be done. No evidence of knowledge of Dr. No prior to the delivery. But what this is, again, even according to Dr. Johnson, their expert, this is a breach of the standard of care to fail to inform, allegedly fail to inform Ms. Velasco that she had had no procedure done. It is a healthcare liability claim.
Counsel, is there a standard of care, a medical standard of care that would apply to the absolute failure to perform, not the decision not to perform, but just the unknowing failure to perform because of, let's say, a lack of communication in the office, for example? What medical standard of care would apply to a decision that was never made? It was just an oversight.
Well, according to their expert, essentially it's a duty to inform the patient when a tubal ligation is appropriate. Here, the doctor recommended it because of the third pregnancy, that it be done at the same time as the delivery. Then that the breach of that occurred, of course, when it's not performed. And frankly, the medical standard of care is going to be based on whatever, essentially, in this case, their expert states. And then, of course, if the case proceeded, Dr. No would have his expert that would essentially agree, I'm sure, with Dr. No that there was no duty here to perform because of the lack of written consent. It would be illegal to do so. And there could be a claim for improper proceeding on a BTL with a lack of informed consent.
Let me boil it down a different way.
Okay.
Normally, when we're talking about medical negligence, we're talking about a doctor who's faced with a circumstance, evaluates it, applies the appropriate standard of care, and makes a medical decision on how to act. And then you're looking at what the risks were, what was it a foreseeable situation, et cetera. In this situation, it's almost a breach of contract when you look just at the failure to perform. Because really, you don't have a medical decision by the doctor. He didn't even know it was going on around him. You have an office that says, we recommend you get, and remember this, I'm not making a factual determination. We have to look at this in the light most favorable to her. So let's set aside the sham affidavit question for the moment, if you would. The light most favorable to her seems to be, she was advised that this was a recommended procedure. She was told what it would cost. She showed up with the money at some point, too late clearly, but she showed up with the money and therefore expected the service would be performed. And it was never conveyed to the doctor, because I think we all know that if it had been, the doctor would have walked in and said, hey, I can't do the procedure that you've just asked for. So clearly the evidence would indicate he had no idea that this had happened due to a breakdown somewhere. And then the procedure didn't get performed. And then we have all this other stuff about the communication. how can there be a medical standard of care on the procedure when he didn't know the procedure was even in the realm of discussion? And that's why it didn't. What's an expert going to say to the failure to tell the doctor that she thinks she's getting this procedure, by the way, that you can't perform?
Well, I think that that's the reason why we all have to come back to the issue of duty. Was there a duty? You can't get to the fact that there was a breach without having the duty, and the duty never arises here because the standard of care requires under List A that you obtain signed written consent. That's the law, and that's the standard of care here. And then
Hold on. This is the only problem I have with this argument is that I think you're conflating the two. And that's what I keep going back to. It's not the fact that he didn't perform it. It's the fact that he didn't tell her. So the duty of care is not whether or not he performed it. Clearly he didn't. And that's what Mr. Lopez is indicating to us. But nonetheless, it's a duty of care to tell your patient the mistaken belief that she that her contraceptive needs have been taken care of have in fact not been taken care of. I think that's the question.
And I would agree there are two different issues, Your Honor. There are
So what's the duty of care in regards to that?
According to his expert, the duty of care is that Dr. No had to inform her that the tubal ligation had not been performed, and he did not do so. So he
and you agree with that?
No, we don't agree with that.
Well, then why are you telling me this?
I'm
asking you.
I'm telling you the summary judgment record, Your Honor. Of course, we
that-
agree that Dr. No breached the standard of care. But they've asserted those, as they claim, various time periods, but it's prenatal, delivery, and postnatal care. They're all healthcare liability claims. Even if a failure to perform is a breach of contract, as was suggested or posited by Judge Ferguson, breach of contract is still under the definition of healthcare liability claim, as long as it addresses the standards of care, breaches of the standards of healthcare and medical care. It doesn't matter how it's asserted as a tort or breach of contract, it's still a healthcare liability claim.
So it's a healthcare liability claim, and?
I'm sorry, I didn't get that last part.
I said, so it's a healthcare liability claim.
It's a healthcare liability claim. And the healthcare liability claim has several elements, the first being duty. We believe under that healthcare liability claim, which is the 7th summary judgment motion, that the summary judgment was properly granted because there was no fact issue created on duty, and there was no fact issue created on damages.
Okay, so you're saying there is no duty for a healthcare provider to correct a patient. So if I come in and I say, I don't have cancer, and the doctor says, the doctor thinks, well, yeah, you have cancer, but the doctor has no duty to correct my belief that I don't have cancer, and so then I don't seek treatment. I just don't understand that.
There cannot be a duty to inform, we believe under the summary judgment record, if there was no duty to do it.
No,
Well,
okay.
Can I add, maybe, are we saying, can we go back then? Are you saying that the acceptance of the payment did not create a duty
To inform.
to inform?
Well, even if it did create a duty, the duty to inform the patient, is that the question?
Yes.
I don't believe that, no, Your Honor, I don't believe so under this record, because Dr. No was never informed. That Dr. No had no knowledge about that. And even if he did, he testified he would not have done anything differently.
But hold on. This is the thing I have a problem with. I understand that Dr. No personally didn't know, okay? But the fact of the matter is, I mean, he didn't see the patient prior her presenting at the hospital. And my understanding was he wasn't present at the August 4th appointment. So it's not whether or not he knew subjectively, but the fact of the matter is that I think the notes give an indication that she communicated her belief that it had occurred. So, I mean, it's not imputed to him subjectively, but the fact of the matter is, you know, it was communicated to to whoever the nurse or whoever was handling that particular appointment. So it goes back to, again, for me, as to if I come and I say I don't have cancer and they know I have cancer and nobody corrects me. I mean, how, you know, I don't understand to me, you're saying, okay, he didn't have a duty to perform, so therefore he didn't have a duty to disclose or correct her misapprehension.
Well, that's one aspect of it, Your Honor. But if you look at the summary judgment record, even if there is a duty to inform, she was informed. The nurse told her, and she agreed to that in her deposition. The only time she doesn't agree is now in response to the summary judgment without explaining why when she
The
agreed.
affidavit. Okay.
Yes.
Okay.
Yes. So she was informed at the postnatal visit that she had not had a BTL.
So if
And-
the affidavit is not a sham affidavit and we're required to take the evidence in the light most favorable to the non-movement, then the evidence most favorable to the non-movement would be that she did report and they did not tell her. If the affidavit is a sham by law, then it falls back to her statement in the deposition you're telling us that she was told, and that would be the light most favorable to her. Am I stating this correctly?
Essentially, Your Honor, but her affidavit, there's more than just that statement, I was told or I was not told. There's a lot of I understands, my understanding is, I reasonably believe. Those types of statements are conclusory. They are no evidence, as we pointed out in our brief. They don't rise to the level of probative and competent evidence to create a fact issue.
Thank you.
Thank you. With that, I would just ask the court to affirm the trial court summary judgment.
Thank you. Mr. Lopez.
Thank you, Your Honor. May it please the court, counsel. I think Your Honor hit the nail on the head when the questions were asked by Your Honor regarding the duty to inform. That's exactly what we're talking about. I don't understand how counsel can say that there was no duty to inform, if in fact that's what she's saying. There is a duty to inform. You have to inform there's a doctor-patient relationship at least until August the 4th, 2014. I don't think counsel addressed the issue of damages either, other than what's included in their brief that says that their damages are, hey, give her $400 back and she's good to go. Well, I think it's an insult to believe that those were measured
We
damages.
kind of hijacked her time before she had a chance to talk about that. But I want to ask you this elephant in the room now. Are you conceding any issue as to claims related to damages asserted arising from the failure to perform, and instead focusing entirely our attention on the damages arising, as you say, from the failure to inform as opposed to perform?
If I understand the court's question, I think that's correct that we are not complaining of the failure to perform the BTL. All right.
Okay.
I think that's fair. I think that'd be a
Okay.
fair statement.
Thank you for the clarification.
Okay. Yes, Your Honor. Let me say first of all that the no expert report was required in this case. Okay, because I think the basic facts are undisputed. That is that he never did the BTL and they didn't tell her he didn't do the BTL. I think everybody agrees with that. But counsel mentions Dr. Johnson's report, and I've noticed that in page 43 of their brief, the appellee states in the footnote 11 Again, Dr. No and Sun City have denied all liability in this case and do not agree with or acquiesce in any of Dr. Johnson's opinions. Well, if that's true, then they can't rely on Dr. Johnson's opinions for anything, whether it's in support of their position or in opposition to their position. The other thing I want to mention is that, and I think this goes back to the question that Your Honor had asked regarding, I think the damage as far as the cost for the next for subsequent pregnancy and delivery. Okay, it is included as a damages in our damages section. Whoever was that, can y'all hear me? Okay, it was included in our damages section that we're asking for future damages and medical expenses related to future medical care, and that future medical care would include the birth of the next child. The one thing that counsel has told this court is that she made reference to Nurse Ramirez. Okay, well, Dr. No said Nurse Ramirez told me X, Y, Z. Well, that's hearsay. Okay, I think that's not evidence. It's hearsay of what she told him and what he told, and then in turn what he told Ms. Velasco. Now, and then she also opposing counsel also states that Dr. No discussed the issue, or may or may not have discussed the issue of whether BTL could be done, and that goes to the issue of whether or not Dr. No consulted with Ms. Velasco. In his deposition, in response to requests for admissions, which are included in the record, the defendant admitted that Ms. Velasco was offered a BTL, okay, and or by Dr. No and or by his staff, okay, and that she had declined the BTL. Okay, that's a request for admission. Then in his deposition, he acknowledged that the issue of the BTL was in fact discussed with her, because he states, quote, "I always bring it up," and as set forth in his own words, namely in the prenatal card, although he claims that the appellant declined it. Okay, so he did discuss it with her. He admits he discussed it with her. So he cannot say that he never knew that she was interested in the BTL, because he discussed it with her, and that's a request for admissions and also an interrogatory answers.
Mr. Lopez, are you saying that he met with her prior to the day of the procedure?
Yes, he met with, no, I'm sorry, I misspoke. He met with her during the course of him being her OBGYN while she was pregnant. He was her doctor.
So he personally met with her.
That's what he says in response to the in his deposition testimony. He says, "I always bring it up," and that she declined it. So that means that he must have spoken to her personally. Okay, he didn't say, "Hey, Nurse Ramirez did it," or somebody else on the staff did it. He says, "I did it." He said, "I always bring it up." Okay, then in answers to interrogatory number 7 and number 9, which is found at CR 1492 and 1493, interrogatory number 7, he denies that a BTL was ever discussed, yet acknowledges in response to interrogatory number 9 at 1493, quote, "I was told that she did not want a tubal ligation." So it looks like he's talked to her and that his staff also talked to her, you know, and that is consulted with her regarding a BTL. Everybody, I think, understands that she could not afford it. Okay, and even their own record has the prenatal card where it says can't afford, and it says CHIP, CHP. Remember, neither on the BTL, neither yes nor no was circled, but it says that CHP, which means that she can't get it for free under the CHIP program. Okay, that's all that meant. They make it sound like it's that no, she said that she didn't want the BTL. All these documents that were presented by the defendant, they're not signed. I mean, they were not created by or marked upon by the plaintiff. They were marked upon by the doctor's own staff, okay? Either by the doctor himself or by the doctor's own staff. I think it's a red herring that where she claims that there was that a BTL was not requested, or that she didn't agree to one, or that he didn't even discuss it with her. I think it's incorrect. But again, Oh, by the way, on the issue of the affidavit, as Ms. Velasquez's affidavit, the reason that sometimes you put in there, I understand, that the words I understand is personal knowledge. Because if she had said, Nurse Ramirez told me ABC, okay, that would be hearsay again. It's improper. But her own understanding of what she heard from Dr. No's office or by Dr. No himself is not hearsay. And it's personal knowledge, what she has in her mind. Whatever she saw, what she heard is based upon her personal knowledge. So I
But
disagree.
does the affidavit contradict her deposition testimony?
I do not believe that it does contradict her deposition testimony at all. But again, I don't have that here in front of me at this moment, so I can't. That's my recollection, Your Honor. Regarding the one thing that we haven't talked about is the intentional infliction of emotional distress. I don't know if the court wants me to address that or not. The court, it's for the court to determine in the first instance whether a defendant's conduct was extreme and outrageous. But when reasonable minds may differ, it is for the jury, subject to the court's control, to determine whether in the particular case the conduct was sufficiently extreme and outrageous to result in liability. And I cite the court to the Tiller versus McClure 121 Southwest 3rd 709 Texas Supreme Court case 2003. So,
And Mr. Lopez, what factual conduct would support that type of claim?
okay, this is, I think it's, again, if you know something, or you have that you, the doctor, know something, or have reason to believe that a procedure has not been done that has in fact been paid for, which you now know has been paid for, okay, it's outrageous not to call this or communicate or even attempt to communicate with your patient to say, hey, we didn't do it. So for many reasons, you better be careful for disease purposes, for pregnancy purposes, all those things. And to keep his mouth shut, forgive my French, but to keep his mouth shut, Your Honor, I think that it rises to the level of extreme and outrageous conduct on the part of the doctor who knew or should have known that he had not done the procedure. And it puts her at risk. Again, it puts her at risk for another pregnancy, which is exactly what happened here. One thing that opposing counsel makes mention of is the August 14th. It's the August 14th record. Well, remember, Ms. Velasco didn't write that record. Dr. No's office wrote that record. And in the history of present illness, it doesn't say patient believes she had a BTL. What it says is, quote, PT, that is patient, had BTL, period. That is what was noted in the doctor's record by the doctor, not by Ms. Velasco. And
Let me ask Mr. Lopez, I'm just thinking,
yes, ma'am.
so in regards to the $400 payment, so let's assume hypothetically that the individual who accepted the $400 payment the day before Ms. Velasco had the surgery or gave birth, didn't understand or didn't know, etc. But my understanding is, based on the record, that Ms. Velasco was all her bills were paid through CHIP, so she would not have had a balance. So let's say 24 or 48 hours later, whenever they reconcile the fact that she paid $400 on a non-existent balance, I mean, even putting aside Nurse Ramirez for the actual direct medical providers, it would seem to me that in terms of the accounting side of the house, they would have known within a couple, 2 or 3 days or a week, hey, a lady paid $400 on a non-existent account. $400 is the amount, I'm sure everybody in that office knows, for that tubal. And at some point, the charges of what the doctor does is in an accounting system has to match up with the amounts that are going to be charged to the clients. So at some point, there was a disconnect even there, even it notwithstanding, subjectively, Dr. No didn't understand and was and couldn't and didn't perform and whatever. But it would seem to me that and it's not in the record, but it's just it's a reasonable conclusion that with receipt of that $400, there would have been some awareness that that's what it was for, and it wasn't paid for, and so it was wrongly paid, before she came back for her postpartum visit.
I wholeheartedly agree with the court. As a matter of fact, Appendix 2, 3 little I's, which I attached to my brief, has the copy of the check. The check was never negotiated. It was given to me. And it says on that check, it says refund. Okay. So they're refunding her for something they didn't do and didn't tell her that they hadn't done. And but remember that refund check of $400 is dated November the 17th, 2015. So I don't know what they did or what they didn't do, but I agree with the court that had they done their job, they would have known shortly thereafter, that is after the cesarean, that she had paid an extra $400 for a procedure that they didn't do. And therefore, again, they had a duty to tell her, we didn't do it. And this is why. She would have been okay with that. She would have understood that. But they chose to remain silent. And I don't know why they chose to remain silent throughout this whole thing. I do not know the answer to that question, but I have my ideas. Especially when they told her, we are not public assistants, go get public assistance if you need it, when she came back complaining that, hey, or asking, why am I pregnant again 15 months later after I had a BTL? That's all I have, unless the court has something further.
No, any other questions? All right, thank you, counsel. We appreciate the spirited, lively debate. I think, there aren't very many cases like this out there. It's both of you made it very difficult on the court, but that's what good lawyering does. So we appreciate your participation this morning, and your case will be submitted based on your oral arguments this morning and your briefs in the record.
Thank you very much. And we have thought out in Dallas finally. Okay, we're thawing out still.
Well, I'm glad to hear that. I mean, I just can't even begin to imagine what y'all have been through.
Don't ask what else can happen.
No, I'm afraid. I'm afraid of the answer. That's why I'm not going to ask that.
Thank you so much. Appreciate it.
Very much, Mr. Lopez. Ms.
Thank
Faust.
you.
Thank you, Your Honors.
Thank you.
Bye-bye.
Appreciate it. Bye.
All right. Let me, you've got to jump back in. I'm going to cut off the live streaming now, but you've got a docket call to attend to, Judge, right?
I do.
All right.
I'm already late for the next setting. So thank you, everyone.
All right. Thank you.
Thank you.